First, you have the right to remain silent. That means you do not have to make any kind of statement. You don't have to answer questions. You don't have to submit paperwork that has your signature, especially papers that admit or confess to wrongdoing. You understand you have that right.
Yes, Your Honor.
You have the right to a jury trial. That means that you and your attorney, working with the state, could select 6 disinterested citizens from our community. And those 6 citizens would be hearing and seeing any and all evidence presented in your case. And those 6 people would decide whether you're not guilty or whether you have been proven guilty beyond reasonable doubt. That's the right to a jury trial. You have the right of confrontation. That means if you go to trial, you and your attorney would have the right to question, cross-examine, or challenge any witness who would testify. You also have a right of appeal. That means you yourself or your attorney himself or the 2 of you together could demand that a higher court review the official record and the evidence in this particular proceeding and case and decide whatever legal challenges you wanted to make. That's called the right of appeal. I caution you that the right of appeal is very important, but it's a little bit difficult to handle. You have time limitations. It requires certain documents and particularly correct information. Nonetheless, you're informed that there is such a right and it is an important right. Also, you and the state, in your particular case, have the right to demand a hearing, this hearing be held in the open public courtroom. Because of the COVID pandemic, we're not doing that. Instead, we're doing it by video conference, which is, as you see here, by computer and such. And I need you to know and understand that you'd have the right to demand that it be done in the public courtroom. The state has that right also. Both sides have that right. So in order to proceed, you and the state have signed what's called a consent to video conference. Those consents are part of the record. And in your case, as in all the paperwork that you have signed, those documents have your signature. And I'm asking you, did you review all these documents that you have signed?
Yes, Your Honor.
Did you review them with your attorney before you signed them?
Technically, no, but I was able to read myself through the documents.
Okay. So do you have any questions about the documents that you have signed?
Thus far, I do not.
All right. I'm going to review several documents with you that you did sign. One of them is a document that, by the way, all of them identify you by name, case number, and court number. Then they have a title. The first one I want to mention to you is one that's titled Defendant's Waiver of Constitutional Rights in Court's Admonitions. That document is very crucial. It tells you, again, this time in writing, what your constitutional rights and protections are. It also tells you that any deal that you've made with the state is not binding on me as a judge. In fact, as the judge, I have the authority and responsibility to say yes or no to your deal. Also, I have the authority and responsibility to assess or impose a punishment. That punishment, there is what's called a range of punishment for a particular plea that you're going to enter. I can, if I stay within the range, I can still give you a punishment that's heavier than what you agreed to. Now, if I reject your deal, saying no, it's over, or if I give you a punishment that's in any way heavier than what you agreed to, in either one of those 2 cases, this document tells you that you'd have the right to start all over again, and nothing that you said or signed would be used against me, or rather against you. Do you understand that?
Yes, Your Honor.
Also, there's a document that's titled Trial Courts Certification of Defendant's Right of Appeal. That document I certified to you that because you've made your own deal, this is your agreement, you give up your right of appeal. Did you see and understand that document?
Yes, Your Honor.
And you signed it?
Yes.
All right. You have applied for deferred adjudication probation. I need to briefly tell you, deferred adjudication probation means that even though you'll be pleading, I think in your case, no contest, which is basically guilty in this court, I will not find you guilty. That's going to be the recommendation from you and the state. I will honor that recommendation, but I need you to understand that you must live up to 100% of the conditions of supervision. If you do that, not only do I not find you guilty, there will not be a conviction in your case on the charge that you plead to. If you fail or refuse to live up to 100% of the conditions, then the state may ask me to give you notice, bring you in, have a hearing. At that time, if it's my opinion that the evidence supports it, I will enter a finding of guilt. It will be a final conviction. Then you'd be looking at 100% of the range of punishment, which in this case will be a fine from $0 to $2,000 and jail from a minimum 72 hours to 180 days. So it is crucially important that you live up to all the conditions. Do you understand it?
Yes, Your Honor.
All right. Do you have any questions so far concerning this proceeding or the documents I've been referring to?
Not so far, no.
All right. Now to the charge, pardon me, state, you have a motion?
Yes, Judge. In this case, the state is going to be waiving the extreme intoxication, and we're going to proceed on DWI first.
DWI first is a misdemeanor class B, punishable, as I mentioned earlier, by a fine from $0 to $2,000 and jail from 72 hours continuously as a minimum to 180 days. To the charge of DWI first or misdemeanor B, Ms. Renteria, how do you plead, ma'am?
No contest.
All right, a no contest plea is considered a guilty plea, as I mentioned earlier. Do you understand that?
Yes, Your Honor.
Did anyone threaten you, intimidate you, or promise you anything other than the agreement, the plea agreement that you're accepting in exchange for the plea of no contest?
No, Your Honor.
All right. The court accepts your plea of no contest. I find that there's sufficient evidence to find you guilty, but I do not. State, what is the recommendation on punishment?
Yes, Your Honor. The recommendation is grant deferred adjudication for a period of 12 months. She will not apply for early termination of that community supervision, a fine of $400 plus court costs, 48 hours of community service, a Crime Stoppers donation of $50, DWI education program, DWI Victim Impact Panel Live, a TAP evaluation, 6 months of ignition interlock.
Okay. Ms. Renteria, do you have children that you help support?
No, I do not.
Okay. And what is your total monthly income?
Thus far, 1,200.
1,200? What do you
Yes.
do, ma'am?
Well, I'm a small business owner, so I'm not
So your salary
doing.
is small, huh?
Yeah, I keep reinvesting into the business, so I don't keep much for myself.
Okay. Good enough. I accept the recommendation from the state on punishment. it is recited into the record. You're granted 12 months deferred adjudication. You'll pay a $400 fine plus court costs. You'll perform 48 hours of community service restitution. You will make a one-time donation of $50 to Crime Stoppers. You will complete in good faith a DWI education program, the Victim Impact Panel Live. You'll submit to a TAP evaluation and the recommendations that therein with the subject to my approval. You'll have 7 days to come into the offices of County Court of Law number 5 so that you can have your thumbprint placed on the documents that require your thumbprint by law. You'll have ignition interlock for a continuous 6 months as a minimum in your vehicle. Your supervisory fee will be $38 a month. Do not leave this proceeding, this hearing, until you have met with Mr. Wright. Are you here, Mr. Wright?
Judge, is going to be Officer Diaz.
Oh, Ms. Diaz is here. I'm sorry.
That's okay.
Mr. Wright was here earlier. Apparently he was Mr. Wrong. Now we have Ms. Diaz.
Yes, Judge. Thank
You
you.
need to meet with her. She will get you started on the probation program. At the probation office, they're going to read to you your conditions. You will sign those conditions and you'll have a copy in your hands. Is that all understood?
Yes, Your Honor.
All right. Any questions, Ms. Renteria?
Not so far, no. Thank you.
Okay. I went to grade school with a man named Renteria. What is your grandfather's name?
Well, they're in Mexico, so,
Okay.
and I'm not from Texas. Yeah, so I don't think.
Okay. Very good, ma'am. All right. Any questions, Mr. Wallen?
No, I have none.
Very good. Then, Mr. Wallen, you're excused at this time unless you want to continue to meet with Ms. Renteria and Ms. Diaz. All right. Mr. Stryker.
Yes, Judge. How you doing today, Judge?
Let's see
Here on
you.
Jonathan Williams, and Mr. Williams is in the courtroom, Your Honor.
I don't see him, but I'm sure he's in there somewhere since you told me he is.
Yes, sir. I'm here. I don't know. Let me. I was just on this thing. I don't know what's on my thing. There you go.
Okay, so you're not in the courtroom.
Oh, I thought you were in the courtroom, Mr. Williams.
No, I'm not in the courtroom. I'm on Zoom.
Okay, all right. Well, as long as you're on the Zoom, we were having video issues, Judge, and so he was in the courthouse earlier today. Is that right?
Yeah.
Okay, and now he's on just video, Judge. Okay, we're ready to proceed, Judge. It's a deferred adjudication on obstruction of a highway, Your Honor.
Mr. Williams, if you do me the kindness to stay visibly where I can see you. And
Yes, sir.
you have to consider yourself being in the courtroom, so you need to uncover.
Yes, sir. You said, okay, what is it that I need to do?
Uncover, take your hat off or whatever that is, a helmet. Okay, all right, thank you, sir.
Mr. Williams, I know it's cold, but it'll just be a few minutes, okay?
All right.
Mr. Williams, you were arrested on the offense of DWI.
Yeah.
Did you hear the discussion I had with Ms. Renteria concerning rights and protections?
Yes, sir.
All right, I'm gonna have to repeat it for you since you weren't officially on there. Please raise your right hand, Mr. Williams. You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. Please put your hand down. Mr. Williams, before we proceed, you need to be informed, and I take the time to do so, that you have constitutional rights and protections. You have the right to remain silent. That means you don't have to say anything. You don't have to answer questions. You don't have to submit written papers that have your signature. You have the right to a jury trial. That means you and your attorney could select 6 people from a pool of 6 disinterested citizens, and they would see and hear any and all evidence, if any, and decide whether you're not guilty or whether you've been proven guilty beyond reasonable doubt. That's the right to a jury trial. You have the right to confront witnesses. If you go to trial, You and your attorney could question, cross-examine, or challenge any witness who testifies. You have the right of appeal. That means you yourself or your attorney himself or the two of you together could demand that a higher court review the official record and the evidence in this proceeding and decide any legal challenges you were making. Those legal, that right is a little bit difficult because it has time limitations and you have certain papers and information that you have to submit. Nonetheless, I inform you that it's an important right that is there for you. You also have the right, as does the state, both sides have the right to demand that this proceeding be held in the open public courtroom. We're not doing that because of the COVID pandemic, but you could still demand that, and the state could too. To proceed, we have asked you and the state to sign what's called a consent to video conference. Did you review and sign such a document?
Yes, sir.
All right. Now, state, I'm sorry, Mr. Williams, there's other things that I need to discuss briefly. First of all, you have a document that's titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. Among the other things, that document repeats the protections and the rights that I discussed with you momentarily, and it does this in writing. This same document tells you that any deal that you've made is subject to the court saying yes or no. That is part of my authority and responsibility. I also will set your punishment, whatever that might be, based on the plea. Also, this document tells you that any deal you've made is strictly subject to my okay. I need you to know and understand that. Also, there's a document that's titled Trial Court Certification of Defendant's Right of Appeal. That document tells you that the court alone has the right to establish the parameters of the appeal. And that document tells you that because you made a deal, a plea bargain, you're giving up your right to appeal. Is all of this clear to you, sir? Did you understand that?
Yes, sir.
And Mr. Stryker, did you guide the gentleman in reviewing these documents and help him sign them?
Yes, Judge.
Did you and the state agree that under 39.14, the state has complied with discovery?
Yes, Judge.
All right.
I'm sorry, but Mr. Williams, you need to show your face.
There you go, Mr. Williams. All right, good.
All right. You need to stay on, Mr. Williams, please.
Every time that I go off my screen or whatever, the thing is that this thing says when I don't know. Can y'all hear me when I'm on the screen? Let me see.
I can hear you clearly.
Can you hear me?
Yes, sir.
Oh, okay.
All right. Stick around. All right. State, is there any kind of motion?
Yes, Your Honor, the state is moving to amend the information to add count 2 of obstruction, and we are going to waive and abandon count 1, and we're going to proceed solely on count 2.
And defense, is there any objection?
No objection, Your Honor.
And does defense waive the 10-day notice of amendment?
Yes, Your Honor.
Based on the no objection and the waiver of the 10-day notice, the court grants this motion. And Mr. Williams, you're no longer charged with DWI. You're now charged with obstruction of a passageway, highway, or waterway. To that charge, sir, how do you plead?
My attorney say plead guilty.
All right. Are you pleading guilty because you believe you are guilty?
Not really, but yeah.
Of obstruction, not of DWI.
Oh, well, yeah.
All right. And did anyone threaten you, intimidate you, or promise you anything other than the plea bargain deal in exchange for your plea of guilty?
No,
All right. I accept your plea of guilty. I find there's sufficient evidence to find you guilty, but I do not. At this time, State, would you recite your recommendation has been worked out between you and defense concerning punishment?
12 months of deferred adjudication, a fine of $300 plus court costs, with $300 of the fine prorabated, 48 hours of community service, DWI education program, victim impact panel, TAP evaluation, random urine analysis for 6 months.
That's correct, Your Honor.
All right. There's not going to be any ignition interlock?
No, Your Honor.
And somebody want to tell me why?
Judge, this was a no accident, no prior DWI history, and the breath test was right at the legal limit, I believe 0.09, Judge.
All right. Okay. Mr. Williams, do you have children you support?
no, sir.
Okay, 0 children. And what is your total monthly income?
$0.
Pardon me?
$0. I don't get any income.
Well, how do you pay for your food and lodging?
I'm homeless and sometimes I stay in a shelter, sometimes I stay at my family house, a friend's house. I go from place to place.
All right. Then the court will approve. I find there's sufficient evidence to find you guilty, but I have not found you guilty. Instead, I'm granting you 12 months deferred adjudication. You will pay a $300 fine. However, that is fully probated.
Thank you, Judge.
That means if you live up to all the conditions of supervision, then you won't have to pay a fine. You will perform. Are you physically sound?
I'm sorry, huh?
Are you physically sound? You're not disabled?
No, I am disabled.
Okay. All right, then you will perform 48 hours of community service restitution. You will do the DWI education program. You will do the victim impact panel. You'll submit to a TAP evaluation and whatever recommendations they make, subject to my approval. You'll submit random urine samples for testing for the next 6 months. Your supervisory fee is waived.
Thank you, Judge.
Certainly, under the circumstances, it'd be an unjust requirement. Mr. Williams, do you have any questions, sir?
No, sir.
Mr. Walland, I'm sorry, Mr. Stryker, do you have any questions?
Not this time.
I didn't hear you, sir.
No, Your Honor.
Okay. All right, Mr. Delco, any questions?
Nothing from the state, Your Honor.
All right, then, that concludes this proceeding for today. Gentlemen, Mr. Williams, do not leave this hearing. You're going to meet with Ms. Deus. She's the lady on the screen there. She will explain to you how to get started on the probation that you're on. You'll need to come by the offices of County Court at Law Number 5 to have your thumbprint put on the documents that is required by law. Any questions, sir?
When do I have to come by?
You have a week, 7 days to come in and put your thumbprints on. They'll help you here.
Okay, all right, thank you.
All right, you stay safe and you stay healthy.
All right.
Okay, Mr.
All right,
Stein,
and thank you, Judge. Thank you for your patience. And
You're welcome.
Mr. Williams, even though I'm not your attorney anymore, if you have any questions, feel free to give me a call, okay? And always report. If you ever lose contact with your probation officer for any reason, come to the court and they'll put you back in contact with them, okay?
I think you
Very
were
good
right
advice,
out,
Mr.
bro.
Williams.
All right, okay. All right, I'll give him a call and talk to him and remind him. I just always like
Okay.
to, with him, I like to repeat myself and remind him over and over again because he's got some issues. So thank you, Judge. Thank you, everybody.
You're welcome.
Yeah.
Take care. Have a good weekend. All right, Ms. Rivera. Mr. Delco, Ms. Reyes, Ms. Flores, Judge Longoria. We're all excused for the rest of the day.